you or someone you know is facing criminal law issues, it simply makes sense to be informed. Our Fine Law video topic is Stages in a Criminal Case. No two criminal cases are alike, but this video will discuss key steps in a typical criminal case. 1. Arrest, booking, and bail. 2. Arraignment and plea bargain. And 3. Trial, sentencing, and appeal. A criminal case really begins when a police officer places someone under arrest, meaning they've been taken into custody and are not free to leave. The arrested person, the defendant, is then booked or processed. Here, a police officer typically records the defendant's personal information and a description of the alleged crime. The defendant is ordinarily fingerprinted and photographed at this time. Depending on the seriousness of the charges, the defendant may be able to post bail to be released from custody until their first court appearance. The bail amount is set by the court. Those who are ineligible for or unable to pay bail are usually held at the police station or local jail until their first court appearance. This takes us to the next stage, the arraignment and potential plea bargain. The defendant's first courtroom appearance is called an arraignment. Here, the defendant usually appears before a criminal court judge who will read the charges. The judge typically asks if the defendant needs an attorney and how they want to plead to the charges. Usually the plea is either guilty or not guilty. The judge will likely also announce the dates of future court proceedings in the case. After an arraignment, the prosecuting attorney and the defendant's counsel will usually attempt what are called plea bargain negotiations. The majority of criminal cases are resolved through plea bargains. The defendant agrees to plead guilty to one or more charges in exchange for a more lenient sentence or so that certain related charges are dismissed. Now let's look at trials, sentencing, and appeals. If a plea bargain agreement cannot be reached, a criminal case will likely go to trial. A jury will look at all the evidence and determine whether the defendant committed the crime, in legal terms, beyond a reasonable doubt. If the jury returns a verdict of not guilty, the defendant is released from custody. This is called an acquittal. If the jury returns a guilty verdict, also called a conviction, the process moves into the sentencing phase. That's where the judge or jury decides on the appropriate punishment. Depending on the seriousness of the crime and the defendant's criminal history, the sentence can include a fine, incarceration in jail or prison, community service, drug and alcohol rehabilitation, probation, or a suspended sentence, which takes place if probation is violated. A convicted defendant may appeal his or her case to a higher court. This usually starts with the State Court of Appeals. In the appeal, the defendant usually asks the higher court to review the case for legal error, whether in the conviction itself or in the sentence that was imposed. There you have it, the stages of a typical criminal case. You'll find more information on criminal law issues right here on findlaw.com. Or if you're looking for legal help now, just click on our lawyer directory to find an attorney in your area. Thanks for watching.